Hello everyone. So in this particular video, what we'll be doing, we'll continue discussing the polity notes which we have made. So I'm going in a sequential manner. So we'll discuss polity right now, then we'll discuss environment and we'll go on like this, right? So let's start. So ADR, what is ADR? ADR is alternative dispute resolution, right? And it is a very important topic of GS2 mains. GS2 mains in the initial second or third topic is ADR only, alternative dispute resolution. And the topic name is separation of power between various organs, dispute redressal mechanism and institution, right? But the thing is right now we are talking about prelims perspective. We will be doing things from prelims perspective, right? So let's see the things which are important from prelims perspective. So ADR section 89 of CRPC 1973 in the first session, this is the sixth session which we are having of polity, right? In the first session, we have talked about CRPC 1973 Criminal Procedure Code 1973. We have seen that it is giving a, what do you say? It is giving a, it is implementing the provision of Article 50. And what does Article 50 talk about? If you don't remember, let's go back and let's see. Article 50 talks about separating judiciary from executive. See, we talk about separation of power, right? So this is Article 50, which is included in TPSP, Directive Principles and State Policy. So Article 50 talks about separating judiciary from executive and public services of the state. See, earlier what used to happen, what is judiciary, what is executive, like DM and these are permanent executive, right? And like prime minister and all these people, CMs and all, they are political executive. Judiciary is judiciary, you all know. Earlier what used to happen, district magistrate, they also used to work as judicial officers. So to separate that, because district magistrate or DM or all these people, they're a part of executive, right? But judiciary is judiciary, right? That is a part. So if you are mixing it earlier, like your judicial magistrate, they will become even the, what do you say, hear civil and criminal cases. So Article 50 told us to separate judiciary from executive and public spheres of the state, and to give implementation or to implement Article 50, CRPC 1973 did the same. So CRPC 1973, you can say that apart from other things, it is also implementing the provision of Article 50, dude. Now let's move back. So sections 89 of CRPC 1973, it provides for, and this is very important actually, this is very good also, this, if you know this information, a specific section. So it provides for various modes of ADR. Now let's talk about things which are important from prelims perspective. What are various modes of alternative dispute resolution? Arbitration is there, mediation is there, conciliation is there, you can read these things. Now let's first of all go to Lok Adalat. It is important from prelims as well as mains perspective, very important from prelims perspective. They can ask you different questions based on Lok Adalat. What they can ask, whether it is a statutory body, constitutional body, what do you say, executive body. So it's a statutory body because it has been constituted under LSAA 1987. What is LSAA? That is Legal Services Authorities Act 1987, and it is a form of public conciliation, which is presided over by 2-3 people who are judges. It's not like anybody, me and you will go and sit there. If you are a judge, you can go. So 2 or 3 people who are judges or advocates with experience, right? And first of all, understand this. So it is presided over by people who are judges or advocates with experience, not any naysayer, although it is a form of public conciliation only. And it has been given the power of civil court up to a limited extent. So it has not been given the powers of criminal court, it has been given the powers of civil court. So there are many things from Plymouth's perspective which are important. Lok Adalat, it is a statutory body constituted under LSAA, right? So there are 4 basic modes of ADR, which we have seen: arbitration, mediation, and conciliation. Just a second. Arbitration, mediation, conciliation, Lok Adalat, and Nyaya Panchayat, right? So we have talked about Lok Adalat, which was very important. Let's talk about Nyaya Panchayat. So Nyaya Panchayat are village courts, which are, they are what they are? They are village court constituted at grassroots level. Sorry, I stammer sometimes. It's a defect from birth. I cannot do anything about it. So you have to bear with me regarding that. So Nyaya Panchayat are village court constituted at grassroots level to resolve petty civil and criminal cases. Very important, dude. They resolve not only civil cases, they even resolve petty criminal cases as well. So this is very important. So now they are guided by local traditions and emphasis is laid on mutual settlement, blah, blah, blah. What is very important here again is all these principles of ADR, arbitration, mediation, conciliation, Lok Adalat, and Nyaya Panchayat, they're based on the principle of natural justice. Now, what is principle of natural justice? We get very confused. There are 2 basic fundas of principles of natural justice. First funda is, you should not be the judger of your own means action, right? If you had done a crime, you will not judge yourself. This is the first principle. The second principle is you should at least hear out the other side. So if you want to see it, I will show you. These are the only two basic main principles of natural justice. Just a second. So as you can see, I don't know how much you can see, but hopefully you can see. Let's see. See how many C I used in the sentence. Good that way. Dude. Okay, fine. Enough of the stupid jokes. So two basic principles of natural justice are, what are the two basic principles? Nemo judex in casoa. We don't need to remember that. What we have to understand is no one should be made a judge in his own cause. It should not be like, no, dude, I am very good, dude. I can do this, dude. I can do that, dude. Dude. No, that is wrong, dude. So no one should be made a judge in his own cause. So first thing first, and second thing is you should at least hear the other party out, right? So yes, that's it. So these are the two basic principles of natural justice. Don't think that it is based on. We can have a confusion that it's based on natural justice, that everyone is equal and all those stuff. No, they're major. See, this is what do you say? Legal terms. So principle of natural justice. These are the two basic principles. Cool, dude. Now let's go back to the notes. Yes, so we have done this. Now let's come back to linguistic minorities. Linguistic minorities, what are the basic constitutional provisions dealing with linguistic minorities? Article 29A. So what does 29A talks about? It talks about conservation of distinct languages, right? It's a fundamental right, right? Because it's 29A, dude. Between 14 to 35. All are fundamental rights, right? All these provisions. So Article 350, it talks about language for grievance redressal. And Article 350A, it talks about instruction and mother tongue at primary stage of education for linguistic minorities. You have why we have written it. And why I've written it here, because see, 29A, 350, 350A, they can give you what are the provisions dealing with linguistic minorities, A only, B only, C only, A or B, B or C, whatever. So you have to remember Article 29A, 350 and 350A. Now, if you want to go and see the Constitution itself regarding what they are saying, so you can see here. See, Article 350, it talks about every person shall be entitled. Hopefully you are seeing it. Article 350, it talks about every person shall be entitled to submit a representation for the redress of any grievance to any officer or authority of the union or the state in any of the languages used in union or in the state, dude, as the case may be. Now, 350A, it talks about it shall be the endeavor. If you read this, you will understand that it is talking about that state should provide. State should endeavor to provide instruction in mother tongue at the primary stage of education to children belonging to linguistic minority groups, and president can issue directions accordingly. So that's it. So these are the important provisions related to linguistic minorities. So we should not be missing these out. 29A, 350, 350A apart from others. Now Saansad Adarsh Gram Yojana. So we have made many schemes. How many schemes we implement in reality, that is a different matter altogether. But one of those schemes was Saansad Adarsh Gram Yojana, SAGY. So it was introduced in 2015. Remember this, these introduction part are important. SAGY, 2014 it was introduced. The basic objective was to develop one village by each MP as model villages apart from the village of their own or their in-law villages. That is an exception. So you cannot go and say that I live in here, my village is this, so I will develop. No, that is an exception. You cannot do that. You cannot develop your own village or your in-laws village also, because see, our wife's family is also our family, dude, right? So that is also an exception. You cannot do that. So to develop one village by each MP as model village by 2016 and two more by 2019. This was the basic objective. Now, again, this is important. Sometimes they do ask regarding schemes, what is the basic unit of development? Gram Panchayat, district magistrate, or means what do you say? Gram Sabha, all those things. So here, Gram Panchayat is a basic unit of development in Saansad Adarsh Gram Yojana, which would prepare what do you say, village development plans. It is an initiative of Minister of Rural Development. There can be a confusion here, since it is a Saansad Adarsh Gram Yojana. So whether it is a scheme under Ministry of Parliamentary Affairs or not, no, dude, that is not the case. It is an initiative under Ministry of Rural Development. Don't forget it. Saansad Adarsh Gram Yojana. Gram means village, and so initiative under Ministry of Rural Development. Cool, dude. Let's move on. Now, parliamentary privileges. What? See, I have only written the basic things which are important. For reading these things in detail, you can go to Lakshmikant and read it. What is very, very important in parliamentary privileges, that it is not applicable for president, right? Although what is president is a part of executive and all those things, he's also part of legislature and everything. But these parliamentary privileges, they are not applicable for president. Very, 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 very important, dude. And they include attorney general. So attorney general will what do you say, assist state or central government in disputes, legal disputes. Similarly, advocate general is the state counterpart of Attorney General. So include it's parliamentary privileges. It is including Attorney General, but President is not included here. And Committee of Privileges will decide whether they are breaching parliamentary privileges or not. Again, what is very important? I have to take a pause, man. Yes, I don't know why I stammer so much. Sorry. Yes, Speaker. So speaker, what does speaker do now? Again, there are various provisions related to speaker. What is very important right now? I have written it here. Sometimes there can be confusion here. Speaker is resigning by writing to whom? So speaker is resigning by writing to deputy speaker, not to president. Generally, we get confused that he must. Why will deputy speaker is what do you say? Subordinate to speaker. First of all, that is not the case, because if you read Lakshmikant or any political book, they will specifically tell you that deputy speaker is not subordinate to speaker. So, but the thing is, we generally feel that way. Why will he write to deputy speaker? He must be resigning by writing to president or someone else. No, he doesn't do that. Speaker resigns by writing to deputy speaker, and that is very important, dude. And he can vote in the first instance during his removal resolution. Why I've written it here? Remember, when there is a tie, generally speaker does not vote. When there is a tie in general matters, so then what do you say? Cast his vote. But when there is a removal resolution of that means we want to, or the parliament wants to remove him, or Lok Sabha wants to remove him. In that case, he can vote in the first instance only during his removal resolution. Cool, dude. So these are the basic things where we can make mistakes. So that's why I have noted it down. Regarding RTI, only Indian citizens can seek info under RTI. So Right to Information Act 2005. So only Indian citizens can seek info under RTI. No NRI, non-resident Indian, is allowed to seek info under RTI. And similarly, for BPL people, below poverty line people, there is zero fee. But for non-BPL people, there is certain fee which is prescribed. So if you want to file an RTI, there will be certain amount of money which you have to submit. But for BPL people, zero fee. Now let's talk about one more interesting thing, and then we will wrap. Now, governor. What are the basic things? What is the basic confusion here is? See, generally we get very confused regarding who is governor appointing, who is president appointing, like in which matter governor is consulted by president, and so on and so forth, right? So let's say remove all those doubts as much as possible. So first of all, governor appoints advocate general. We have just talked about he is the state counterpart, like analogous to attorney general at center, advocate general. So here he will assist state government in legal matters, advocate general. And so governor is appointing advocate general as well as members of SPSC, State Public Service Commission. But SPSC members can be removed only by president. Very, very, very important. Although State Public Service Commission members are appointed by governor, but they can be removed only by president. Very, very, very important, dude. And they are consulted by president. Who is consulted by president? Governor is consulted by president on appointment of high court judge. Similarly, this governor also nominates one Anglo-Indian to LA, that is Legislative Assembly. Remember, two Anglo-Indians, president can nominate to Lok Sabha. Here, governor, this is called parallel study. Governor can nominate one Anglo-Indian to LA, that is Legislative Assembly. Similarly, he also nominates 1/6 member of Legislative Council. So that's it, dude. We'll keep until here only. Revise all these points. These points are important from prelims perspective. Very, very important. Questions can be framed in more ways than one, right? So that's it. See you people next time. Bye-bye.